Okay, so good afternoon, everyone, and welcome, and thank you for joining us for today's presentation of Startup Legal Protection, What You Need to Know. And this is brought to you by Innovate 518, the Capital Region Innovation Hotspot, which is a collaborative network of incubators and accelerators helping to drive tech innovation in the Capital Region, as well as the UAlbany Innovation Center, which is UAlbany's incubation program. Anna Galliano, principal at Galliano Law Firm, and Josh Koss, lawyer at the Town Law Firm, will be presenting today. And I'm going to hand it over because we have 1 hour, so I'm going to let them get started right now.
This is Anna Galliano. Thanks for joining Josh and I this afternoon. I'm a lawyer with a solo practice out of Clifton Park, New York. I've been practicing law for about 27 years. I've also been an entrepreneur, having started my own company several years ago, and very much appreciate the challenges of a startup business. What precipitated this particular presentation is that in the past several years, we have found that we're spending more time fixing issues facing startups rather than preventing them. So we thought that we would share with you just some of the pitfalls to look for when starting your own company. And with that, I'll let Josh introduce himself, and then we'll move on.
Thanks, Anna. I'm a real estate and corporate attorney at the Town Law Firm in Albany. I'm relatively new to the area. I did a crazy thing and moved here in COVID a little less than a year ago. And I've been very impressed by the startup culture in the area. So I think and hope that this presentation proves particularly relevant given the startup climate. So we'll dive right in. If I can get the presentation to work. So one of the things that we wanted to touch upon from the get-go is the timeline that people should have in mind when they're starting a company. From day one, they should be thinking about what their exit is. It seems a little bit counterintuitive. You're starting a company. Why would you think about ending it? But right, what's your goal when starting a company? Certainly, you want to grow it. And then at the end of the day, you want to capitalize on it. You want to reward yourself for your talents and your efforts. That notion is particularly relevant to this presentation because if you're thinking about your company in the short term, legal tasks may seem smaller than they actually are. You're pressed for cash, you're trying to get off the ground. Legal is something that, it's just a negative on your bottom line. You want to push it out of mind. You don't want to worry about it. If you expand your timeline and you're thinking about building and protecting and eventually exiting, then legal is more likely to seem as important as it actually is, right? It's really essential in terms of setting up your foundation to do the other things that we'll be talking about.
Do you want to move forward to sort of our
absolutely. Absolutely.
So as you can imagine, having practiced for many years, I've seen a lot. And so I have some stories that I'll share with you along the way. But for purposes of this particular presentation, we just came up with a hypothetical. And it's Joe and Sarah, they're engineers upstate. Sarah has an idea. It's a swim ladder for pets. And they, of course, form a company and they decide to use an online service because it seems a lot cheaper than hiring a lawyer. It saves time and money. So for example, they use LegalZoom, and what could possibly go wrong?
And we'll be answering that question quite literally as we move throughout.
So the initial facts are Joe lends the company $25,000 and he's going to contribute some engineering services. Sarah actually has an MBA in financial, so she'll be contributing some accounting services. She also is an engineer. She'll contribute some of her engineering services, and this is her idea. They decide that they're going to own the company 50-50, and they decide to form a Delaware corporation. And 6 months later, Joe's offered a really good job in California, and he decides that he really needs to take it. And he'll still own 50% of the company. And Sarah says, well, you're not going to be contributing any longer. You've only been here for 6 months. You really should give back your 50% ownership. And does Joe have to give back his 50% ownership? And the answer is, well, no. And if they had, taken the next step and entered into what we call a founders agreement, which I'll explain in a second, or a shareholders agreement, that would address what happens when a founder or shareholder leaves the company, this might have been helpful. And the founders agreement can be very simple, or it can be very comprehensive, but at a minimum, it should contain the couple of bullet points on the next slide.
And just to preview the bullet points before we dig into the specifics. So the founders agreement, it's really the product of a conversation among the founders. And as we dig into the details, we'll see why it's actually a good thing to ask the big kind of what ifs, the hard questions up front, as opposed to waiting until the back end when bad things might occur, because then you're not prepared for it when they do happen.
So your typical founders agreement is going to address, what amount or type of contribution that you are contributing to the company, whether it's in the form of cash or IP, and your amount of ownership, the vesting of your shares, the repurchase rights, and an evaluation method upon repurchase or exit. And, typically in today's startup world, you'll want to see at a minimum a 1-year cliff vesting period. So for example, if Joe and Sarah own 50-50 and they authorized, let's say, 10 million shares in their Delaware certificate of incorporation, they might issue 2 million shares to themselves, 1 million each. And with a 1 year, with a cliff vesting, let's say, which is typical of 4 years, their 1 million shares would vest over 4 years, with the first 250,000 vesting after 1 year, assuming they're still with the company. So in Joe and Sarah's case, if Joe had left after 6 months, Joe wouldn't own any shares. And Sarah wouldn't find herself in a situation where she's now partners with what we call a non-contributing co-founder. Also, Joe and Sarah could have defined Joe's 25,000 contribution as a loan to be paid back when the company started to make some money, or Joe could have vested in some small percentage of his initial shares in exchange for the 25,000. The purpose in any event is that they could have prepared for, on paper, this particular situation. And the valuation method is simply so that if Joe had left, say, a year and 6 months and was vested in, say, the 250,000 shares plus, the company and or Sarah would have the right to repurchase the shares from Joe, the premise being that Sarah does not necessarily want to be left holding the bag with a non-contributing shareholder. And just briefly, I'm just going to share a recent situation that I had to illustrate how crazy it can be when there is no founders agreement, or there's a founders agreement and it doesn't say what you expected. So I had two women that owned a company 50-50. And one of the women, Michelle, she had a couple of patents and 20 years of experience in the construction industry. And the other woman, Kim, had a financial background and some contacts that would have been helpful for obtaining grant money. And they actually had an attorney prepare a founders agreement with vesting provisions, but no 1-year cliff vesting. So after 9 months, Kim left to take another job. She still owned 9% of the company. Michelle, who gave up her full-time job, was making no money, found it very challenging to attract another person with financial experience to join the company because no one was particularly interested in joining a company where a non-contributing co-founder owned almost 10% of the company. And, Michelle, not surprisingly, didn't think it was fair that she would be working very, very hard. And if at the end of the day, there was a payday, Kim would reap the benefit of Michelle's continued hard work. Michelle offered to buy Kim out. There was no valuation method in the founders agreement. So she offered to buy Kim out with a $40,000 note that would be triggered upon $1 million financing, but Kim refused. So Michelle wanted to dissolve the company and start a new one. Well, under Delaware law, you need a majority of the shareholders to vote in favor of a dissolution. At the time that Michelle wanted to dissolve, she had a slight majority because she had continued to vest over time. But there is case law that might support a claim by Kim that Michelle dissolved the company to kick Kim out, also known as minority shareholder oppression. Without telling you what she decided to do or a whole host of other issues that were involved, you can see how the failure to anticipate these issues, which we do for a living, causes a lot of problems. So that's just one example of just what can happen when you don't think about these things up front.
Yeah,
and the fact that they're, go ahead, Josh.
I was going to say it's really helpful to keep those examples like that in mind. It's sometimes clients balk a little bit at the notion of doing something like vesting. They'll say, "We trust one another. Why do we need something like that?" And it's less about not trusting one another and more just recognizing the fact that life happens. We're all human beings, and it's important to structure your company in a way that properly incentivizes the participants to contribute to the company.
Yeah, and I always recommend to clients that if it's not me, they should ask another attorney or attorneys and interviewing them to provide them with a sort of a template, if you will, of a founders agreement so that they know what to think about and consider when speaking with their co-founders about how they want to structure this. And the vesting is not a penalty, if you will. It's a way to make sure that all of the co-founders are invested, if you will, in the long-term success of the company.
Sure. And then two last things I wanted to add on this slide. It's not always a case of Joe versus Sarah or one person versus another. Oftentimes terms can be mutually beneficial. For example, with repurchase rights, if Joe and Sarah had contemplated, somebody leaving and the person staying being able to purchase the departed's rights, that provides liquidity to the person who's leaving, and it allows the person who's staying to retain ownership rights. Kind of a win-win. And then the last comment I wanted to make on this slide, a lot of people think that it's kind of necessarily correct for there to be equal ownership. That's not necessarily the case, but if you do decide that there is going to be equal ownership, you'll want to make sure that you contemplate deadlock provisions. What happens if you want to go in one direction and the other person wants to go in the other? What path does the company take?
Yeah. So with this particular slide, where Joe and Sarah receive a notice in January from their Delaware registered agent that their franchise tax is due in March and the registered agent fee is also due. This slide sort of emphasizes or highlights an issue that's often overlooked by people who just think, well, everybody likes to invest in Delaware corporations, so let me incorporate in Delaware. And sometimes it's a premature decision, depending on, how many years you think it is going to take for you to sort of get this idea off the ground and running and be in a position to present it to investors. The reason why investors typically like to invest in Delaware corporations is because there's this sort of a special court in Delaware, Court of Chancery, and it's well-established law, and it provides lawyers with, guidance and predictability for Delaware corporations in general. However, if it's, you're 2 years in and you're not making any money, then, sometimes the $400 or $500 fee that you get hit with each year is pretty tough to swallow. I was recently approached by a woman with 2 businesses. She's located in New York, who couldn't understand why her lawyer set up both her companies in Delaware, because for the past 2 years she had been making no money. There was really no income to speak of, but she was paying out these fees each year in Delaware. And if she wanted to know what she could possibly do to resolve this, does it cost money to originally incorporate in Delaware? Does she just write all of that off and start new and then incur all the fees that she would need to expend in order to reincorporate in New York? So it's definitely something to consider.
And I'll just add something to keep in mind as we move throughout the presentation. There's a lot of kind of important to-dos that Anna and I will be highlighting. They're important in of themselves, but they're also important in terms of setting up a legal entity and making sure that a court treats it as such. And we'll get into that a little bit later. Just keep it in mind that this is one of those things where filing, if you organize in Delaware, filing your annual report and paying your franchise tax is important in a larger sense.
So one of the things that people often overlook too is once they have incorporated in Delaware, whether they form a regular corporation or an LLC in Delaware, they still need to file an application for authority to do business in New York. And it's not necessarily cheap. It costs about $225. And if you're a Delaware LLC and you're filing an application for authority to do business in New York, you need to meet the publication requirement for LLCs in New York, which is an added expense as well. And sort of the consequences of not complying with this is you can't avail yourself of the courts in New York. So for example, if you needed to sue a vendor or a supplier, or you had a contract and somebody breached it, you wouldn't even be able to go after that person in small claims courts. And also I find that if an investor is going to be investing a significant amount of money, or even not a significant amount of money, when they're doing some due diligence, if they find that you haven't observed your corporate formalities, they tend to wonder what else is lurking, behind the scenes that hasn't been taken care of.
That's right. And I'll just touch upon the phrase physical presence. It really means just that. Think of it as a lower bar rather than a higher bar. It can be as much as having a store or a large office in New York. It can be as little as having a sales representative living and operating in New York. So be sure to pay attention to that.
So this is sort of the scenario 2 with Joe and Sarah, but they are going to form a New York limited liability company. So Joe will still give the company $25,000 in engineering services, and Sarah will contribute her services as well as her idea. Joe will own 75% and Sarah will own 25%. And then 1 year later, here are the facts. Their company is making money. Joe insists that he should receive his $25,000 back first, and that any remaining profit should be reinvested in the company. But Sarah wants the profits to be distributed to their members, to the members according to their ownership percentage. And Joe believes that he gets to decide because he owns a majority of the company. And they didn't have an operating agreement. And I can't begin to emphasize how many startups ignore the importance of the operating agreement. What I typically see is a startup which formed an LLC using maybe an online service and a standard operating agreement, which was provided to them as part of the service, but was largely ignored until there was a problem. And Joe would be right, because without an operating agreement, anything the LLC would do would be governed by the New York State limited liability company law, which is very open-ended. It pretty much leaves it to the members to structure in an operating agreement almost pretty much anything that they want with respect to governance. So if they had an operating agreement, it could have been that even though Joe owned 75%, he could have received 75% of the profits or taken 75% of the losses, but Joe and Sarah could have voted equally on any decisions that the corporation or the company was going to make. Interestingly, I recently, I had a nice young man, Steve, who came to me with a particular problem. He had borrowed $10,000 from his grandmother to purchase 10% in a New York LLC. And after 5 years, he wanted to know where his share of the profits were. It turns out there was an operating agreement, but it was a one-page, standard online provided operating agreement that allowed the 90% member to decide whether profits would be distributed or reinvested in the company. And the 90% member had no intention of distributing the profits. He kept reinvesting them in the company. So Steve wanted out, but the one-page operating agreement prohibited Steve from transferring his interests. And even if he could transfer his interests or sell them, who would want to buy his 10%, knowing that they might never see a distribution of profits? So it just, once again, it just emphasizes how important the operating agreement is. And again, when you're speaking with an attorney or attorneys, if you're interviewing them to help you, you should ask them to provide you with either a sort of a template operating agreement that highlights all of the things that you should be thinking about and speaking with your co-founders about, so that you can make some decisions and think about these issues, and then finalize the operating agreement when it's time, earlier rather than later.
Sure. And I find that a helpful way of thinking about both the problems that not having an operating agreement, or that not reading your operating agreement can present, or the solutions that having an operating agreement can provide. I tend to characterize them in three buckets. So one is you get involved in an entity and you don't read the existing operating agreement, and it ends up working against you, as with the Steve hypothetical. The other is you have some sort of an arrangement with a partner or partners, but you don't memorialize it in an operating agreement. And New York State limited liability company law default kicks in, and there's a dislocation between what the default law is and what you had envisioned for your company. And then the third is something that people don't usually think about, but talking with a good startup attorney will raise issues that you'll want addressed in your operating agreement that you may have not thought of initially. And so it can be very helpful in triggering a conversation between you and your other members in terms of contemplating what you want your company to look like and how you want it to grow.
Two things that I'll point out. One, oftentimes what will happen is nobody has really thought about what happens if one of your co-founders dies or is disabled and can no longer contribute in certain ways. And in specifically in the case of death, I mean, no one ever wants to think about it, but it happens. And then suddenly you find yourself partners with your co-founder's spouse or next of kin, brother or sister. And you really want to anticipate those types of situations. And second, I recently had somebody come to me that said they wanted to be able to sign their contracts as the president of their LLC, as opposed to managing member. And you can structure your operating agreement so that you have a board of directors and officers, such as a CEO, president, or vice president. But one thing to consider is that if you would like to have a non-member participate in the management of the LLC, that language has to be in your formation documents. So in New York, it would have to be in your articles of organization that the company can be managed by non-members. For example, this particular company that recently approached me wanted to make a non-member the vice president of business development. Well, it turns out the only way to do that was to have to go back and amend the articles of organization and file in order to allow them to do that, and re-amend the operating agreement to provide for management by officers and board of directors.
So we'll move forward with some more mistakes that you can make when setting up your company. So we talked a little bit about your company being a distinct legal entity, and this slide and the next point directly to that. So in the continuing hypothetical, Sarah has been purchasing office supplies or other items, maybe gas for the company on her personal credit card, and there ends up being a dispute about funds. Joe demands receipts for the funds or for the expenses, the company expenses, and Sarah hasn't been saving the receipts. What are the consequences of that? So beyond there now being an internal controversy between Joe and Sarah, the largest consequence of that is external. A, if you're audited. B, and most significantly, this is grounds for a court doing what's termed piercing the corporate veil. So when you establish a legal entity, one of the main reasons why you do that is to protect yourself, liability protection, right? You're operating no longer as an individual, but as a company or as a member of a company. Well, courts say that needs to be real. That needs to actually be happening on the ground. A company can't merely be what's called an alter ego. So if, for example, funds are commingled, if you're commingling your personal funds and the funds of the company, a court will or may lift the liability shield or the veil of the company and go after your personal assets and allow creditors to go after your personal assets, including investments, your bank account, your car, your home, and so this can be quite serious.
Yeah, I'll one of the reasons why I have a checklist of the things that, not just the sort of legal documents that you want as part of setting up your company, but on that checklist, it's also getting an EIN number from the IRS, which you can do easily online, and I tend to walk my clients through it if they want to do it themselves. And the EIN and the articles of organization or your certificate of incorporation and the operating agreement is what you provide to the bank to open up a separate bank account. You get a checkbook and a credit card. And for the most part, you will get those things. And you go into Stewart's and you go to get gas. But you're also, maybe buying some bunch of last minute groceries for home. And you're claiming your car and your gas as a business expense, but the groceries are actually personal expenses. And I really try as task oriented as it may seem, and somewhat overwhelming to our busy lives. It's really, really important to get separate receipts. And I actually keep two separate envelopes or to scan them into two separate accounts. One is personal and one is business. So at the end of each month, if I'm doing an accounting, I know what's business expenses and I know what's personal expenses.
So another mistake that Joe and Sarah did in our hypothetical is not complying with New York's publication requirement. So when you organize a company under the laws of the state of New York within 120 days of formation, you need to publish notice of that formation in 2 general circulation newspapers in the county of formation. The cost can seem like a pain in the butt, and every county in the area, Albany, Rensselaer, Saratoga, Schenectady, it ranges about 125 to 275. This is one of those things where if your timeline is short, right, that you're envisioning for your company in your head and you're rushing to get things done, that seems like it might not be worth it. But there are significant consequences to not complying with this requirement. One is, if you'll recall our prior slide on application for authority to do business, the state of New York can suspend that if you don't follow this requirement. And then another is, if you'll recall what Anna previously talked about in terms of you contemplating an exit or someone coming in and looking to invest. If I'm putting myself in the shoes of an investor or an acquirer, and I see that this hasn't been followed, I'm now thinking, what else hasn't been done that should have been done?
Yeah, and I'll share my own personal mistake. It's no pride of authorship, I guess. Years and years ago, when I was involved in my own startup company, I didn't do the publication right away, and we had a bunch of lawyers come in on behalf of a company that was interested in purchasing us. One of the things they noticed was that we had not done our publication requirement. So we went ahead and met the publication requirement, but it held up due diligence and the deal for over 8 weeks. And that's not something that that's not a position that any of you want to be in. I think, Josh, this particular slide just sort of goes back to the last 2 slides when an investor is doing due diligence, right? And this sums up what we've been talking about. You failed to comply with the publication requirement. You have no operating agreement. There could be all sorts of disputes, and in the end, an investor's not necessarily going to be that interested if this is the way you've been running your company all along.
Right. And I think the take-home point is shortcuts, particularly legal shortcuts, upfront save you neither time nor money on the back end.
So Joe and Sarah engage a manufacturer company to build a prototype. They've worked out all their problems. They got all of their ducks in a row, and they're doing okay. But during this process, they realize that they haven't signed a non-disclosure agreement with the manufacturing company, and they have invariably disclosed their idea to the manufacturing company without having a non-disclosure agreement in place. And when you have publicly disclosed your idea, it starts the clock running on your need to file a patent on that idea. If in fact you're going to file a patent. If you're not going to file a patent, then you've essentially disclosed a trade secret, which is no longer a trade secret, because a trade secret is only a trade secret for so long as you protect it as a trade secret. And a non-disclosure agreement is evidence that you have taken the necessary steps to protect it as a trade secret. So the purpose sort of this slide and the next slide is to highlight the importance of non-disclosure agreements right from the very start of your company.
Sure. In addition to a non-disclosure agreement, you might wish to file a provisional patent application. There are pros and cons to each. You should, as with all things in this presentation, consult an attorney for specific advice, but some of the pros and cons to weigh when choosing between one of those 2 options to protect your idea. NDA is a little bit quicker to draft, less costly. It's more difficult to prove breach, though, is the downside. provisional patent application provides a little bit more protection, takes more time, costs a little bit more money.
Yeah, but the NDA also buys you some time. I'm going to address this slide in 1 second, but I do want to say something about there's some background noise. I'm not sure where that's coming from, but if you have a great idea and you think it's worthy of a patent, you should begin the process of obtaining patent protection right away. But this is not to suggest that you go out and hire a patent attorney, right? There are resources that you can access on your own to at least investigate whether there's any prior art out there that you need to consider in making your decision. There are patent agents that you can be referred to. The one thing that you need to keep in mind is that the US is a first to file country. It is not a first to invent country. A provisional application can act as a placeholder to eventually file the patent application, which is a non-provisional application at that time, if you're at all concerned.
And just
moving to this particular slide that's in front of us on the screen, the hypothetical is that Sarah filed a patent in her name prior to forming NewCo, and she leaves NewCo and she goes into a business with her best friend to commercialize the same patent. But she never assigned the patent to NewCo, so the patent essentially belongs to Sarah, and NewCo doesn't own anything. And I think I'm just gonna, by way of illustration, I'm gonna give you 2 examples of how this occurs in real life. Going back to the company that was owned 50-50 by the 2 women, Michelle and Kim, Michelle had never assigned her patents to the company, and you can imagine Kim's surprise. So when Michelle wanted to dissolve the company, there was really no issue over who owned the patents, whether it was Michelle or the company. So it's pretty important that you establish up front the actual assignment in writing. And second, I just had a guy recently come to me because he had received a cease and desist letter from an attorney representing a California company for trademark infringement. This guy had been operating his company for a long time. He's been very successful for many years, and it never really occurred to him to search the Patent and Trademark Office, the trademark database, to see if the name that he was using was trademarked. He actually bought the domain, and the domain was an infringement of the California company's valid US trademark. So he found himself in a position where he had to change his name. And the advice that I give him is not only to search the USPTO trademark database, but to search any and all available domains. So I just want to highlight that when you're thinking about a name for your company, it's not enough just to search the state's corporation databases to see if the name is available. You have to take it 1, 2, 3 steps a little further, and make sure that you're not going to get in this guy's situation down the line.
And just to bring things full circle with a very simple point, which is when you're operating a company, you're operating, or you should be operating, as a distinct legal entity. You need to consider either licensing or assigning, right? Licensing is a right to use. Assigning gets you a little bit more, a lot more actually. It transfers title to the company, but you need to be considering one of those, because you're not, or again, you shouldn't be operating as an individual.
So this is scenario sort of number 3. It's a little different of a fact pattern because Sarah owns her company 100%. She forms a New York LLC, and she doesn't think that she needs an operating agreement because it's essentially an operating agreement with herself. So she sort of ignores that part of the corporate formalities. And she eventually gets sued for, let's just say, some unpaid debt. And this sort of goes back to what Josh was addressing about piercing the corporate veil, if you will. And in New York, even a single member LLC needs an operating agreement. So, for example, I'm a single member PLLC, and I have an operating agreement, and it's important to have. The other thing is, even when regardless of whether you're a single member LLC or any kind of LLC, I've been told by some of the litigators that recently judges are using the failure to meet your publication requirement in New York as a possible reason for allowing any plaintiff to pierce, again, that ugly corporate veil. And so this slide just once again illustrates and highlights the importance of those corporate formalities, as much as no one likes to pay attention to them.
And it can seem.
And I think that, Josh, is this the last slide?
It is.
I think. Yeah, I would say that in closing, you sort of, in my closing, my personal closing, having done this for 27 years, I've found that some of the most successful companies will have as their co-founders, people who might recognize that, maybe they're not necessarily the right person to be the CEO, and that's okay. And they might bring a CEO in and take a different position. But I do know this, that the co-founders, at the most successful ones, at least make an attempt to try and understand or appreciate some of the legal aspects of what we've been talking about, at least to know enough when to spot an issue and ask a question.
Yeah, I can't think of a better closing than that. At some point, we'd like to open the floor up to questions. I know that Nat also wanted to take a moment to speak. I'm not sure if we have a preference as to which order we take.
No, Josh, we can go right. I'd like to go right to questions if we could. So folks in attendance, this is your opportunity to pose some questions to Josh and Anna. Thank you very much. Very informative, great presentation. So any questions for Josh and Anna at this point?
You can type them in the chat. Oh, I see someone typed in the chat, thank you for hosting this information presentation. Is there any way that you can email us? Yes. So I forgot to mention, for those especially who joined late, we are recording this, so we will post it on our website and push it out on our social media networks. So we'll email you, those that have registered, the direct links to that.
And if you guys want to reach out to us, here's our contact information.
Great. Just a reminder, if anybody does have questions, you can unmute and fire away. If maybe I'll try to get the conversation started, Josh and Anna, with an initial question myself that I know sometimes we hear a lot from some of our teams, or where we see teams maybe getting lost. Do you, either of you, do some work in the specialization around the optimal level of formation? Because a lot of times we'll see companies initially form, let's say, as an LLC, but then down the road they might want to take on some level of investment, and then they have to revisit that formation structure, hire counsel, go back, and change that. So what recommendation or advice, do you have at the initial formation level to kind of look at the longer term strategy and planning for, how the team, the startup might want to be accessing capital and possibly taking on investment?
Well, so, I mean, that's a sort of I'll give you a two-part answer to that. So if you think you're going to be taking on capital and investment, and your exit strategy is shorter term rather than a longer term, you're not always going to be a closely held corporation for the most part. I mean, you're actually thinking of someday, your company is going to be worthy of an IPO or emerging with these new SPACs and going public. It does make sense to incorporate as a Delaware corporation off the bat, because investors are just attracted to it. I do have one client that was a Delaware LLC, and one particular investor in their second round of investment wanted them to be a Delaware corporation. Fortunately, Delaware is so corporate friendly that they allow for a very easy conversion from an LLC to a Delaware corporation. Not so easy in New York. New York requires the New York LLC to actually merge out of New York into a Delaware corporation. That it's not that time consuming. Those types of documents have been drafted, so it's not as if we're reinventing the wheel. But the filing fees can get somewhat up there. And we're talking maybe $1,500, $2,000. When you're all said and done, you could be looking at $2,500 to $3,000 at the very top in filing fees just to do the actual mergers. So you form the Delaware corporation, you take the New York LLC, and you merge it into the Delaware corporation. There's also ways of doing reverse mergers as well. So Matt, I think if I really answer your question, do I deal in the optimization? Yes. Can it be done? Yes. Can it be relatively simple? Yes. Can it be expensive? Yes. But it can happen. So if you haven't necessarily planned, it's not the end of the world. It can be done.
Great. And I just want to remind folks too that on our Innovate 518 website, one of the first projects that we actually undertook, and Josh and Anna, if you're actually not familiar with it, we would love second, third, fourth sets of legal eyes to take a look at it, but we actually have a tool called Corporation in a Box, which does provide some very foundational educational information about optimal formation levels. And we worked with Albany Law School to put that together. So it provides you, if you are at that ideation stage and really just looking at forming, some really good kind of basic, but really good information that becomes interactive. It kind of works through a decision tree, and we'll prompt some YouTube videos that will go into some deeper dives associated with that. So feel free to take a look at that. Any other questions? I put a note in the chat. Feel free to unmute.
I had a direct direct question.
Great.
Is there an approximate range of cost of starting, informing, and using all the agreements initially as students who want to access your services that you talked about? I think this goes for startups as well, not just students who, may be strapped for cash and not have much. Because I know we've heard that in the past as well, regarding initial costs of starting a business.
So Maria, what I've done in the past, out of my own practice, is if somebody is willing to do the legwork, a lot of the legwork, I'm happy to help coach them through, steps 1 through 10, what needs to be done, sort of how to do it, right? Where do you access the sort of, if you're gonna file something with New York State, how much does it cost, and what does it look like, and where do I get the forms? I give them links to the forms. I give them links to getting an EIN number. I can provide you with sort of the basic operating agreement, initial consents, and the like, with a lot of the information left out for them to consider and sort of fill in. If they're willing to do that legwork on their own, the costs can be the filing fees, plus a little bit of time. But if they're willing to do it on their own, it doesn't have to be that expensive at all.
And I would just add 2 plugs, one for town law and the other for the region in general. Similarly, as with Anna, town law, we pride ourselves in being flexible, and we're happy to come up with arrangements that work for our clients, particularly when there's the understanding that we're kind of growing together. And that's good for the client, and that's good for us. And then the plug for the region is, when I moved a year ago, it was from New York City. And even first year, second year attorneys in New York City, the hourly rates are absolutely eye-watering, and you're not necessarily getting a bang for your buck. And one of the things I love about this region is its affordability, and the quality of products and services, that quality isn't sacrificed by virtue of the affordability. And that absolutely applies to legal services offered in the capital region as well.
That's great. That's really good to hear. Reassuring. Are there any other questions? I know we're here at 2:00 at the end, but I throw it out there if anyone has any last questions. And if not right now, I think Matt is gonna close it out for us.
Yeah. First off, I just want to thank you, Josh and Anna. Really appreciate you lending us time from your busy schedule, to share your information. Hopefully, Josh, it's one of the other things you've found about our region. It's one of the things I know that we pride ourselves on at Innovate 518, is, really being a collaborative region, and really understanding that in order for us to become a true burgeoning, entrepreneurial ecosystem, we have to all work together. The startup teams that we see, there's a lot of them. There's a lot of good potential in the technologies that we see coming out of this region. But the entrepreneurship game is a very high touch process, and in many instances, many of our partnering organizations, we're all touching these different startup teams in different capacities. We all have strengths and resources that we're bringing to the table. And the goal is of Innovate 518 is really to give those startup teams one central place where they can start to navigate where to go to get those responses and answers. So I think we all try to work together, and I think you guys are really showcasing that yourselves as two attorneys from two different law firms coordinating and collaborating together to share your information and resources to our startup ecosystem. So again, we can't thank you enough for your time and efforts. Again, to those who are in attendance, if you have any questions, any information, please feel free to reach out to myself or Maria. We'll be glad to get back to you. We pride ourselves on being responsive and really trying to plug you in to making sure that we can get you the answers. In many instances, we don't have the answers, but we usually know where to go to get them. And so I really want to encourage you to take advantage of the resources of Innovate 518 and all of our affiliate partner networks. And again, we don't do this work without all of our partner incubators and accelerators and entrepreneurial service providers and co-working spaces. It really is a community effort. So if there's nothing else, no other questions for Josh and Anna, thank you very much. And we'll hopefully see you for our next educational workshop session that we're working on planning. So thank you so much for tuning in.
Thank you, everybody.
Thank you.
Thank you,
Enjoyed
everyone.
it. Thanks.